I promised Jill this year she wouldn't give it.
All right, good afternoon to everyone. We've got quite a crowd here. Must be a lot of interest in garnishment law. We've got a couple of preliminary things to let me first go over. Bring Susan in here too. I want to begin by introducing everyone to Susan Butler, my new assistant, and Susan's doing a great job. She started about a month ago, I guess, was it?
November 14th.
Yeah, not till November 14th. That's right. And we're very, very pleased to have Susan working with us. So anytime you need to get something information-wise to me, from me, she'll be the perfect person to make contact. So thank you for coming in, Susan. We also have Graham Goldberg. There's Graham. Graham is our intern for this session. Graham is a student at Georgia Tech, majoring, Graham, in
business and public policy.
There you go, public policy. So we're pleased to have Graham with us. You have a sheet that's been handed out, I believe. Have you got them?
The subcommittee chairman have this.
Subcommittees, okay. You've got it where we're... Okay, you got your subcommittees and the bills. Well, we've also got you had a sign-up sheet of information, didn't you?
Yes, sir.
Has that been
It has.
circulated?
Yes, sir.
So if all the members would please fill in the information so we've got good current contact information for all of you, that would be most helpful. We have bills, as you know, from last session that either did not leave the committee, or upon leaving the committee went to rules and did not get out of rules in time. Those have been recommitted to our committee. I'm going over a list of the bills as assigned to subcommittees, so everyone has information about that. There's a House Bill 121 by Representative McKillop, which is a bill assigned to the Lane. These are all, first of all, Lane subcommittee bills I'm reading to begin with. That's House Bill 121. House Bill 245 by Representative Rusty Kidd, dealing with suretyship and co-signers. That's been also assigned to Lane. House Bill 558, which is by Representative Spencer. That is a contracting and bidding preference for local resident businesses for public work projects. That has also been assigned to Lane. House Bill 594, Representative Burns, limited liability companies in Lane's committee, and House Bill 643 by Representative Jones. This deals with secondary metal recyclers and identification by fingerprint of persons selling it. Senate Bill 52, which is Senator Butler's bill, and this will be one that we'll wait on. We can go ahead and have subcommittees, but as far as coming to the committee, we'll wait until after day 30. But it is a bill we have from last year. In Jacob's subcommittee, we have House Bill 445 by Representative Welch. This is dealing with foreclosure of property. And we have also House Bill 711, a new bill filed by Representative Lindsay. And this is the spousal privilege, an important issue that we're looking at under the evidence code, and that'll be assigned to Jacob's subcommittee too, excuse me. So those are the bills to watch with interest. The only bill we have on the calendar today is a House Bill 683, which is my bill, and for the hearing on that, I'm going to ask the Vice Chair, Representative Jacobs, to conduct the hearing on it.
Thank you, Mr. Chairman. The only bill on the agenda is House Bill 683. I'll go ahead and call the bill and recognize Chairman Willard to present it. Oh, but can you pass me the sign-up sheet there? All right. Chairman Willard.
Thank you, Mr. Chairman. If I can remain in my seat, I'd appreciate that and make the presentation.
Wherever you want, Mr. Chairman.
Thank you. A little history is that this past year we had a matter that was reviewed by the State Bar and their Committee on Unauthorized Practice, which deals with the question of filing of answers, as it is called, by garnishees in our courts. And after that review, the committee recognized that the filing by a corporation, and specifically dealing with entities which are not in the true sense individual, but recognized maybe legal persons, but these type of entities could not represent itself in court and had to be represented by an attorney. That matter came up before the Supreme Court for review and approval. It was approved by the state Supreme Court, but we did have a part of the opinion, statements by State Supreme Court Justice Namias, which pointed out that he felt there were things that could be done, perhaps by legislation, that could aid in alleviating this burden that we may be placing on businesses by requiring the use of an attorney for filing a response. Now, I looked at this and talked to a number of people. I know the State Bar has had an interest in it. The State Bar also set up a committee a couple of months back, which I had some involvement with. The committee's need was to address what would be a way of resolving this question about the filing of responses in the court. I personally felt and have drawn the bill on the basis that it's truly not an answer that I see in the sense of the legal sense that we qualify and address what is an answer. I mean, you have a person who's brought in as a party, either a plaintiff or defendant, and specifically a defendant to a legal cause of action, and they have to make a filing which is known as the answer. So we use the term answer in that sense. But what I really see that a garnishee is doing is responding to an inquiry by the court, and in making that response, telling the court what they have as far as property or monies that may belong to a person who is in fact a defendant in another action. It does, of course, have a separate filing number. Yes, it is taken as a proceeding in that sense, but I also feel like we have other things that address somewhat the same thing, and I think of in the vein of a corporation filing what we call discovery. They may not be a party to action, but they're under direction from the court to file a response to discovery as to what documents they may have that could involve the specific litigation. So I started working with our good legal counsel, Ms. Travis. We batted around some ideas, and expressed to her what I felt were matters to be addressed in the drafting of a bill, and you have before you the latest iteration of that discussions. It's LC 294997S, and what we're attempting to do here is more than just maybe the question about the what is this response, we'll call it, but recognizing who are parties that need to make the response. And also one of the continuing, I think, problems we had with garnishees and businesses was a unclear or maybe a provision dealing with service that was in conflict with what I call the recognized statutory requirements of service. So we've also tried to address that, and Mr. Chairman, what I'll do is go through and give some of the highlights of the bill. And if you start on page 1 at line 15, we have what is a new provision going into the garnishment law as Section 18-4-1. There's a new paragraph as a part of that, I should say. And that paragraph is really taking the old Section 18-4-1 and divided into two parts. The new Part A says, as used in this chapter, the term garnishee answer, garnishee's answer, or answer of garnishee means the response filed by garnishee responding to a summons of garnishment detailing the property, money, or other effects of the defendant that are in the possession of the garnishee, or declaring that the garnishee holds no such property, money, or other effects of the defendant. And then Part B is the current existing law. Page 2 and Section 2 is just, you'll see the beginning where we've taken the term now, and you'll see this used throughout the redrafting of the provisions of this bill, and we have the term garnishee answer used. The important section is Section 3, and it has several things that we've done. This is a section that deals with the definitions, and specifically, as used in this code section, the term entity, and this is important, means a public corporation or corporation, limited liability company, partnership, limited partnership, professional corporation, firm, or other business entity other than a natural person. And the second part of that is defining public corporation. Recognize that we have, since the provisions that became declared by the State Bar and the State Supreme Court, you have a lot of governmental bodies also caught up in this. In fact, the state has been caught up in, you might say, in the sense the state receives garnishments, and the state, as a matter of like business practice in the past, has been mostly someone who's in a trained, qualified position who can go through and prepare the response for the court, is now having to turn that information, once it's prepared, into the hands of an attorney and file it on behalf of the state. The same thing is happening with corporations. So we define public corporations to mean the state of Georgia or any department, agency, branch of government, or state of Georgia political subdivision, as such term is defined in Code Section 50-15-1, or any public board, bureau, commission, or authority created by the General Assembly. That Section 50-15-1 is about as broad a definition I think we could find anywhere that dealt with what is defining a governmental arm, body, agency, department, whatever it may be. Section B is, again, a very important part, and I'd like to read it out loud. When a garnishment proceeding is filed in a court under any provision of this chapter involving an entity as garnishee, the execution and filing of a garnishee answer may be done by an entity's authorized officer or employee and shall not constitute the practice of law. If a traverse or claim is filed to such entity's garnishee answer in a court of record, an attorney shall be required to represent such entity in further garnishment proceedings. Mr. Chairman, let me explain some information about this that a lot of people may not be aware, and frankly I was not clear and aware of the fact that prior to today we've had a provision in our state law dealing with what is probably, I'd say, addressing better than 80% of garnishments, and that is the fact that if you file a garnishment in magistrate court where the jurisdiction is up to $15,000, there is already a provision that allows a corporation, and that garnishment is against a corporation. There's already a provision in the law that allows that corporation to file its own response without the aid or involvement of an attorney. And that provision has been used, of course, for quite some time. Now, maybe a lot of businesses and banks may not be fully aware of that with what came out as far as the State Bar ruling and the Supreme Court's confirmation of that, but that still exists, and that was also recognized in the opinion of the State Supreme Court as being an exception. So we've already had an existing exception. It's only been within the limits of what is to be the powers and the limits of the magistrate court. So what we're saying here now is that the filing of this response for any court is not going to be in the true sense of an answer, but it is a report being made by the garnishee expressing from a review of their files, their information, their records, what assets or properties they may have money-wise belonging to the named defendant, and telling the court and reporting that information and perhaps filing the monies with the court. And so we have gone a step further, saying, recognizing that that is not to be considered as an act of law, as an act that requires the use of an attorney. As we say under Section C, an entity's payment into court of any property, money, or other effects of the defendant or property or money which is admitted to be subject to garnishment may be done by an entity's authorized officer or employee and shall not constitute the practice of law. So we try to make it clear as a public policy finding and statement that that is how it would be recognized. As we go to Section 4, 5, and except for number 6, beyond that section, you'll see the changes made are only dealing with where we use, there may have been only the term answer, and we made it as being a response of the garnishee and not in the true sense what we call an answer. Let me talk about Section 6. This is the provision that I think has also caused a lot of difficulty over the years in the courts. Because what you would have is a garnishment may be filed and service is then made by taking the garnishment, say, to a bank, leaving it with a teller, leaving it with someone who may be in a secretarial position at the bank. Same thing sometimes with employees of businesses. And what you had, if you read the lines that have been struck through, I'll read it for the benefit of those in the audience. 18.4-23 states, service of a summons of garnishment shall be made by serving the agent in charge of the office or other place of business where the defendant is employed. In the event that such service cannot be made, then service of summons of garnishment upon the agent in charge of either the registered office or the principal place of business of a corporation shall be sufficient. That is the part that has caused confusion, because it conflicts with really what we have as stated provisions directing how service is to be made upon a business such as a corporation or a limited partnership. And so we felt that the proper correction for that was to add and have it stated, as I'll read as follows: service of a summons of garnishment shall be made as provided in Code Section 9-11-4, and that is the provision which specifically addresses the service of whether it be individuals, corporations, or any type of business. So we think that is the proper direction to give to parties in the use of the garnishment proceedings. As you go through the rest of the bill, Mr. Chairman, you'll see that everything else is really addressing just the clarification of the garnishee as to what he or she is responding, or it is responding as being a response to the court and not, in fact, what we generally consider and reference as being an answer. That, Mr. Chairman, covers my summary of the bill. I'll be happy to take any questions.
All right. Questions for the author, Representative Hatfield.
Thank you, Mr. Chairman. Chairman Willard, a couple of questions I have. One is, to your knowledge, is an administrative proceeding considered a civil action under Georgia law?
I'm not sure if I can clearly answer that. I'm not saying that the administrative proceeding would be one filed, for instance, with the
Office of State Administrative Hearings, or that might be referred to the Office of State Administrative Hearings.
I don't know.
I would submit, my understanding of the law is that it is not a civil action. Okay. My question to you would be, would you be in favor of allowing non-lawyers to represent individuals before the Office of State Administrative Hearings?
Well, I think those become adversarial, and that's the difference we're trying to draw here. It's not an adversarial in the garnishment until you have someone file a traverse to the response by the garnishee, and then it may become adversarial. But I think what you'll have in an administrative hearing could, in fact, rise to being an adversarial proceeding.
Okay, but you do agree with me that from from a strictly technical standpoint, that would be treating corporations different than you treat individuals in allowing corporations to be represented by non-lawyers.
Administrative proceedings?
Yes, sir.
Treated differently from what we're doing here, you mean, or?
Yes, sir.
Yes, sir.
Okay. And do you agree that the provision in Section 6 dealing with service of process, that what you're actually proposing to do is constrict the methods that are available to serve a garnishee under existing law, that you could serve I don't see it as a bank teller could be served, but a person who is in charge of the office or place of doing business. And we're talking about where the defendant is employed. So there is actually an extra avenue that you have under existing law to serve a garnishee, but that you would be taken away here.
Well, I'll speak from what I've heard. I haven't had any personal experience, Ms. Hatfield, but there have been instances where they would go into a business and serve one who is not, in fact, a manager, someone who's recognized as authority in the office. They have gone in and served tellers at banks and sought to have this recognized if it was challenged as being a proper service, and the courts have sometimes done so. So I think what we're trying to say is we have a standard. It's been a recognized standard that we use under the Civil Practice Act, and the appropriate way of making these documents filed, served with the proper person would be as we have it in that code section.
If I may, just one final follow-up.
Yes, I don't see it as being restrictive. I see it as being really a clarification. Thank you.
Well, I'm saying that what you're doing is actually taking away what is currently an extra method of serving a garnishee, and it would seem to me that public policy would would favor if you have a situation where you have a legitimate garnishment that's to be served, that we would want to promote those garnishments being served in any lawful manner. Additionally, and I'll wrap it up here, that in terms of, say, for example, as you said, serving a bank teller or some other employee, the language of the statute that exists is very, very clear that you must serve the agent in charge of the office or other place of business where the defendant is employed. So I doubt there'd be very many banks where the teller would be running the show, but may stand to be corrected. Thank you.
Yes, sir.
Of interest, before I recognize the next question, I actually have obtained a default judgment against a bank for failing to answer a garnishment where the summons was served on a branch manager in Rockdale County. We'll recognize Representative Hatfield one more time.
I was just going to say, Mr. Chairman, I'm sure that the bank did not hire a lawyer of the quality of yourself defending that.
Hence the default judgment. Representative Oliver.
I support this bill and this narrow exception about practice of law. The Georgia Supreme Court case that talked about courts of record and the Supreme Court's authority to manage did lead me and some others to introduce a bill last year that said OSHA is not a court of record, should be allowed for non-attorneys to represent themselves. That is a little bit of an inconsistency out here. In the past, this committee has not been willing to kind of solve that problem, and I just want to point out these inconsistencies.
Thank you, Ms. Oliver.
Any further questions for the author? Seeing none, we'll go ahead and recognize individuals who have signed up to speak. I've got three who want to speak together. David Rayner from the Georgia Chamber, Kate Jackson from the National Federation of Independent Business, and Ellen Fleming from SunTrust Bank.
Thank you, Mr. Chairman. If it pleases the chair, I've got a letter of support that I'd like to circulate to the committee for their consideration.
Give it to Brandy.
Thank you, Mr. Chairman and members of the committee. I'm David Rayner with the Georgia Chamber of Commerce, and on behalf of the Chamber and our statewide constituency of businesses of all size and across the industry sector, I appreciate the opportunity to be here today. First, I would like to commend Chairman Willard for his swift action in addressing this new costly burden to the business community in response to last September's Supreme Court decision. This issue has garnered tremendous concern throughout the business community, and as a result, our organization has made it a major priority this session to see it addressed. It has been fully vetted through our Law and Judiciary Policy Committee at the Chamber, as well as our Governmental Affairs Council here at the Capitol. In an amicus brief filed October of 2010, the organization asserted that responding to a summons of garnishment is administrative in nature and does not involve the application of legal principles and reasoning, and therefore does not constitute the unauthorized practice of law. For smaller businesses, this has been a added burden because many do not retain legal counsel, and many times these services prove to be very costly. So I have with me today Ms. Ellen Fleming with SunTrust Bank to speak further to the issue.
Thank you, Mr. Chairman and Chairman Willard and the committee members. My name is Ellen Fleming. I am with Senior Counsel and First Vice President at SunTrust Bank, and I'm here today on behalf of SunTrust Bank as well as the Georgia Chamber of Commerce in support of the bill. I am directly involved on a daily basis with garnishment answers and related court hearings. Requiring to file a garnishment answer through an attorney is not in the public's interest. The recent change resulted in a significant increase to the cost of doing business in Georgia and places an unduly large administrative burden on small and large companies with little or no benefit. Corporations already have an incentive to respond to garnishments quickly, efficiently, and accurately. A corporation is held liable if it fails to respond and is subject to defending a traverse to its answer to the court if its response is inadequate or inaccurate. For these reasons, businesses have already adopted policies and procedures, most of the time with advice of counsel, to comply with garnishment statutes. The completion, execution, and filing of an answer by a non-attorney employee of a corporation should be allowed because, as it was already stated, it largely involves administrative duties and the application of simple mathematics. There is no legitimate reason to impose substantially greater costs on businesses responding to a garnishment than would be for a response to a federal or state tax levy. The work is exactly the same and the liability is exactly the same for doing the work incorrectly. That would be, again, the liability on the garnishee for the judgment that is associated with a garnishment. The garnishee is not a party to an action in a garnishment proceeding, nor is it bringing an action or defending a cause of an action, assuming a traverse has not already been made to its answer that the garnishee has filed. The garnishee is merely a third-party provider of facts to the court for the court's judgment on the action. The cause of action in a garnishment is between, as Chairman Willard already said, between the plaintiff and the defendant. Thus, an answer to the summons of garnishment should not be considered a pleading in a court of law, necessitating the involvement of an attorney. House Bill 683 has crafted a workable, effective, and reasonable solution to the unintended consequences of the recent Supreme Court of Georgia action. It has the strong support of the Georgia Chamber of Commerce, SunTrust Bank, a wide range of large and small businesses, and other financial institutions. I strongly recommend the adoption of House Bill 683 without reservation. Thank you for your time, and I'd be happy to answer questions.
Do you want to add something?
Sure. Mr. Chairman, members of the committee, my name is Kyle Jackson. I'm the State Director for the National Federation of Independent Business here in Georgia. Represent about 8,000 small employers. I represent kind of the net effect of the court ruling is that it's a tremendous hurdle for small employers to hire an attorney for a pretty standard procedure, one that they haven't had to do before. And as most of you can imagine, most small employers don't have an in-house counsel. So it is a new added cost. Thank the chairman for his work on this piece of legislation, and we wholeheartedly support it. I would ask for your support as well. Thank you.
Questions for these witnesses? Seeing none, thank you for your testimony today. Next up is Judge James Altman, Council Magistrate Court Judges. Thank you. You need to pull a microphone to you.
Yes, sir.
Judge?
Originally, I was coming up here to say we've reviewed this. We appreciate the addition of the extra words in a court of record, which made it have no impact on the magistrate court, and therefore we'd have no problem with it. What I've noticed as we've been talking is that in Section 6, the change to 911.4 makes the service provision for the counting of days different than what we use in every other action in magistrate court. Because you don't start counting days until the return of service if greater than 5 or 7 days is not in the magistrate code. So this one type of action would have a different way of counting days. We could resolve that by saying Code Section 911.4 or OCGA 1510, I think it's 43, if the action is filed in magistrate court. But I believe I'm correct that under 911.4, if the return of service is not filed within, it's either 5 or 7 days, the time to run for an answer does not begin until the filing of the return of service.
We're talking about service.
Well, yeah, but what's day one for the filing?
Not filing answer or filing response, but how is service going to be made upon a party?
Well,
that would be the time frame required for making their response.
But the provision that says you don't count day one for an answer until the return of service is in 911.4. Okay. It's 911.4H, if I remember correctly. Correct.
Yeah.
And that rule does not apply in all other magistrate court actions. I wanted to come up here and say it has no effect on us. Do you have any questions for me?
But the answer deadline, the answer deadline for answering a garnishment summons is contained in the garnishment statute. So
if that's the way you read it, then we have no problem with this action. It has no effect on us. Thank you very much.
Okay.
But I can see somebody raising that as a question, at least, since 911.4 says what is day one, potentially differently than a man.
I'm not dealing with that. We're dealing with the service specific. Judge Altman, I think what I'm trying to think through this with you, and we didn't say all provisions of 911.4 shall apply and be the last spoken word of the legislature. We're narrative is saying, how do you make service? Service shall be made in accordance with. Now, if I'm only talking about service, I'm not looking at other things that may be addressing the magistrate law that also may be addressed within the provisions of 911.4. I'm only talking about that area. How and who do you serve? Does that make sense?
Yes, sir, it does.
I didn't say all provisions of 911.4 shall apply to garnishment proceedings.
I just anticipate we're going to have an argument about this in court. You're right. I think you're right.
I'll defer first of all to my outstanding legal counsel.
If there's concern about all of the provisions of 911.4, I think actually the line on 85 speaks only to service of summons.
Yeah.
So I think that narrows the reader.
Yeah.
But if there was concern, that the other way to edit this would be to be as provided in, and I believe it's subsection G is what controls in 911.4 for service of process.
It is.
So you could say as provided in subsection E.
All right. So now 11E would be the one you want to just.
I would like to.
Would that address what you feel is the issue?
Yeah. No. Yes. Absolutely.
All right.
I mean, and I'm just trying to obey the law of unintended consequences in trying to imagine the next argument in magistrate court.
Gotcha.
Not create problems here. I think we don't have a dog in this fight
Okay.
as to the corporation's
Good
answer.
point.
So, I'm sorry. Any questions?
Any questions for the judge? Thank you.
Thank you. And if I may be excused, I've got a calendar down the street.
Absolutely.
Appreciate
Understood.
it.
Thank you,
sir.
Judge. All right. Well, we're working on that question. We still have two witnesses.
911, please. You got it. Okay.
Clay Jones, Georgia Association of Manufacturers or Manufacturing?
Manufacturers.
Okay.
But either works.
All right.
Mr. Chairman, members of the committee, Representative Lane reminds me not to talk about the sales tax on energy, so I'll keep my comments to the garnishment proceeding. We want to thank you, Chairman Willard, and others for bringing forward this bill. I'm with the Georgia Association of Manufacturers, and we support the bill. This isn't a time, we believe, to be adding additional burdens to businesses, whether they're small, large, or medium-sized. The bill does a good job of restoring the status quo that everybody understood and worked with prior to the Supreme Court decision. And the Supreme Court ruling came as quite a surprise to many of our members, and my email inbox lit up a couple of days afterwards with several folks saying, what does this mean? So we think the bill strikes an appropriate balance and addresses the issue of concern, and we wholeheartedly support and ask for your support. I'll take any questions, Mr. Chairman.
Questions for this witness?
Thank you.
Seeing none, thank you for your testimony.
Graham, go upstairs and get it from. Can you get it from your office?
Let's see if I can't pull it up here too. All right, Mike Culbertson, Georgia Credit Union League.
Mr. Chairman, if it pleases the chair, I can testify right from here. All we want to say is this is much needed legislation. We appreciate it very much, and credit unions of Georgia really do support this as a cost containment measure. Thank you.
All right, thank you, Mr. Culbertson. All right. I'll call on Chairman Willard to close things up, and then depending on how quickly we get the code book back down here, we might stand at ease for a minute or two. Chairman Willard.
Thank you, Mr. Chairman. What we're missing is the pocket part. We know there's been some change in 911-4, so we're going to wait and get that back. But I wanted to wrap it up by stating, as we have talked about, there's been a wide interest in what we're looking to do here. I might add there was a state bar committee that supported the provision being changed. That state bar committee is continuing to do its work because there are other things under the garnishment law as it currently exists that we think may need to be reviewed, possibly modified. We have some onerous provisions dealing with the default provisions. If you don't file your response in time or improperly file your response, and you get into a default situation. So those are things to still be examined. Our main concern at this juncture was seeing the fact that the business community of our state is being put at an unnecessary burdening cost with having to do something differently that they've frankly been doing for the last who knows how long, 50 years probably better since we had a garnishment law. The fact is that they have done this as an administrative task and not recognize it because they're not really a party to something. They haven't been accused of doing anything wrong unless there may be a traverse filed. So that's why we're saying they're not, in the sense of our judicial system, viewed upon their role as a defendant. So with that understanding, and to say we've applied the same principles with a business responding in discovery, they're not a party, but they're under a duty, a statutory duty to make that response. So we feel there's the same standards to be applied by a business that's not accused of doing anything wrong, just that you've got to make a response at the inquiry of the court. So, Mr. Chairman, I am supportive very much of this legislation and would ask the committee's favorable consideration.
There is one further question. Is that Representative Welch? Representative Welch.
Thank you, Mr. Chairman. Chairman Willard, isn't the the purpose of Section 6 and relating back to the Civil Practice Act, a way to ensure that there's fairness. I mean, what we're talking about in this situation is you have a party that is seeking to secure funds as a result of a judgment, and we're asking for the employer to tell us exactly what is available in terms of property. The way that it's currently written, you can have a sense of, and I'm not to suggest that the current chairman has engaged in some gotcha litigation over there, but you can have some situations where the default judgments rendered are actually result in a negative consequence to the consumers that are associated with the business, because those costs are passed on down, as well as just to we're not getting to what we want to get to, which is an actual amount of property that the company has relevant to that employee. And so that way the person seeking the garnishment actually gets a true and accurate statement. So placing the burden onto the registered agent of the company, the person that's typically going to receive litigation documents, is the appropriate party to get the most accurate answer. And so I think that this is a revision that's necessary. I think it's prudent and one that we should move forward with.
Thank you.
Ms. Travis, where?
Yeah, I know. With kind of, because subsection E is personal service, subsection F is other service, subsection J is alternate service.
Mm-hmm.
You got other provisions about summons and all.
Yeah, you have summons in A, B, and C. You have waiver of service in D. So
Mm-hmm.
I've come back with, I'm thinking 911.4 is okay, but and I have to say frankly, I was not quite 100% following Judge Altman's concern.
Thank you. I think you've got something you were suggesting might be just another belt and suspenders on it.
Sure, and I mean, as I understand Judge Altman's concern, I mean, it's an argument that some litigant will make in magistrate court, and with so many magistrates across the state, I mean, every once in a while you're going to get a bad decision out of that potentially. So what I would suggest is actually, instead of trying to narrow down the reference to 911.4, just clarifying the language at the beginning of the language on line 85. So you would insert the method of in front of service and then strike made. So it would read, the method of service of a summons of garnishment shall be as provided in Code Section 911.4. That's just a suggestion. Representative Hatfield.
Thank you, Mr. Chairman. I was just going to suggest I'm going to vote against the bill for reasons that I previously stated, but just in terms of getting this right, I would suggest that at the end of line 89 that you add something like, provided that nothing in this subsection shall be construed to expand or contract the time for filing an answer as otherwise provided in this article, or something like that. I mean, so you just deal with it head on.
Would not what he suggested with regards to defining it being only the method of service that we're dealing with here and nothing more?
I don't know. Yeah. Whatever y'all feel comfortable with, you have to defend it later.
All the courts have to defend it. I just get through.
All right. Is there any further discussion on the bill before we take the bill under consideration? All right. That being said, the bill is now on the breast of the committee. Any motion? Is there a motion on the bill? There is a motion to pass by the majority whip, second by Chairman Lane. Any amendments?
Mr. Chairman.
Mr. Chairman.
I would offer an amendment beginning on line 85 under Section 6 to start that section to read the method of and make S on service a small s. At the end of the line, the existing line, strike made, so that the provision would read, the method of service of summons of garnishment shall be as provided in Code Section 91114. That is the way it would read by the amendment. 911.4, excuse me. 911.4. Second.
There's a second on that amendment. Any discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor of the amendment say aye.
Aye.
All those opposed, no. The amendment carries. Any further amendments? Seeing none, the chair calls the question on the bill, and that is to give a due pass recommendation to LC 294997S, House Bill 683, by committee substitute as amended. All those in favor say aye.
Aye.
All those opposed, no. The motion carries. With that, I do want to recognize Judge Campbell from Fulton County Superior Court, former member of this House, joining us today. And speaking of former members of this House, former Representative Kevin Levitas is with us as well. Chairman Willard, it's all yours.
Thank you. Let me advise everyone that passing the committee, I've had conversations with our leadership in the House. I've had conversations with parties on the Senate side. I think everybody is anxious to stop the hemorrhaging that's going on in the state with the business community. So our plan is to proceed with all possible due speed to get the bill on both bodies for vote and hopefully approval, and then in the hands of the governor as quick as we can, so maybe he will look favor upon signing an early bill. With that, unless there's anything else to be brought before the committee today, we'll stand adjourned. Thank you.